Friends, in our previous video discussion, we had a discussion to with what is land acquisition, what is the new enactment speak upon with, why the new enactment was brought in, then what is the constitutional provision governing the land acquisition, and later on we also made an attempt of understanding the social impact assessment and how does this social impact assessment is going to be discussed with. It is going to be carried with. So once having done the social impact assessment, the subsequent comes is the food security, or I can also say you in this, my friends, that is while carrying this acquisition process or proceedings, where if the appropriate government finds that there is a necessity of any such land for the benefit of public or for the use of public, or where if it is used for the purpose of public-private partnership or for that of a private company which would be used or beneficial for that of the public concern, then in such cases the land acquisitions can be effected with, or land acquisitions can be carried upon with. But in doing so, even the social impact assessment, the experts who are going to have a study on this should least look in, I'm speaking, at least I can say, when I say least, at least they should look in to the land which are going to be acquired with. And especially where if it is a case of an agricultural land, then they have to look in to that whether the land is being used for the purpose of an multi-cropped grains producers, or where they have also to look in whether such land what is going to be acquired is an irrigated land, or whether it is a multi-cropped plantation or multi-cropped is being grown on that land has to be looked in. And wherever it is so, the legislation also says this, that is to the extent possible that where if a land that is going to be acquired is a multi-cropped land, or where if it is an highly irrigated land, then such land what is going to be proposed for acquisition has to be given up. That is, in any case of development project, if this acquisition is going to be made, then that should be taken as a last resort on the part of this proceedings, or on the last part of as a part of acquisition. That is where if such land is necessarily required, there is a compelling situation on the part of the government that that land is required for the purpose of the public benefit, and there is no other alternative is left out to that of the government or before the government, then they can go for this acquisition only, whereas in case of development project. I repeat this, my friends, that is when they go for an acquisition of any irrigated land or multi-cropped land for the development project should overweight or outweigh the project of this multi-cropped or irrigated land. Only then they can think of going for the acquisition of that kind of a land, and this is because made for the purpose of food security, which is dealt under section 10 class 1 to 10 class subclass 4. So the provisions have laid out in this as how the government has to look when an acquisition is in respect of those irrigated lands, or plenty, I can say vastly irrigated with, or basically completely irrigated with that of the acquisition which they are going to make in. And as I then said to you, that should be the last resort and no other option is left over before the appropriate government to go for that of the acquisition of land. And if it has made a compelling situation on the part of the government, then with these restrictions also they have to undergo with the two safeguards that they have to go in, or that they have to follow in. The two safeguards are something: one, that is where if the land is acquired, suppose say 10 acres of land is acquired, which forms to be within the belt of land acquisition, then that equivalent to that of 10 acre of land, which is, I'm repeating, that is if the land is a multi-crop, because out of several lands I'm speaking, out of the lands in total lands in acquisition, maybe 10 acres of land could be a multi-cropped land, or it could be an irrigated land. In such case, the government is required to give such an equivalent land of that 10 acres, which should be cultivatable in the form of multi-grain or multi-crop or an irrigated land. In the way I can say you this, my friends, the waste land, what is in the hands of a company should, that is in the hands of a government, sorry for taking the company there, in the hands of the government should be converted into an irrigated land. And that land should be given to that, the purpose of having growing certain crops or certain things as that they were growing upon with. That is, in this development project, they have to take this plea, they have to take this undertaking that they will be converting the same equivalent amount of land for the purpose of its irrigation. That is, I'm not speaking they'll be going to give you an irrigated land. No, the wasteland should be converted to an irrigated land, and that land has to be given and for the purpose of irrigation. That's what it says. The conversion shall take place to this effect, and it should be transferred upon with. Sometimes it may not be possible also to do this. Where if it is not possible to effect this, then the amount equivalent to that of the land which is going to be acquired, the agricultural land which is going to be acquired with, shall be considered in the terms of value, and that amount has to be deposited by the appropriate government, whether central or state government, as I then said to you. We were continuously speaking upon with this. That is, the government has to deposit such appropriate amount, calculating out what would be the amount of rupees that they are going to take in, that is, that they are going to incur on this, and that deposit amount, what is being made, whether by state or central, it has to be spent only in respect of the agricultural financial issue as concerned, that too more particularly in providing the food security only. They have to give it. So these are the two safeguards which has been made for the purpose of giving out this food security, or these are the two safeguards which the government has to undertake while providing the food security. In fact, there is always a say this, my friends, that says that it is when the lands have been acquired, we generally call it as arable land, where an arable land is under the acquisition process, and if that arable land is going to hamper the food security of the country, or if it is going to hamper the supply of the food materials to that of the people, then such construction, that is such acquisition, would result out in the total destruction of the agricultural land in the state. So in that regard, it says this, that when a land is going to be acquired, which would be the form of food security, because lots of yielding is being provided from out of that irrigated land, then the same amount of land has to be given with, and the government has to make it sure that the land is being given to, that is a barren land is to be converted and given to the same purpose. That's why, my friends, in Supreme Court, in case of Dashodandan Singh and other versus state of Haryana, I repeat this, it is Dashoda Singh versus state of Haryana. It says, it appealed saying like this, it made an observation saying like this: the government policy has to be made, has to be implemented so as to compelling the zamindars and farmers to cultivate all the agricultural land. And the courts have also appreciated the legislation to the effect saying that the legislation should also be enough to contribute to the increase of food grains in the country, that is by way of production of food grains in the country, to increase the food production and supply of food production so as to ensure the sufficiency of food security. So in this way, we see that the Supreme Court has quite number of times it has come over and again of having saying that this food security is very necessarily required, because that the right to food, right to living is one such a fundamental right. So taking this as a consideration, it said this, that is, when the land is going to be acquired with, it says that such land what you are going to acquire in should be not of that land where it is multi-cropped or irrigated, but if you are doing so, the appropriate remedy has to be equally provided in that regard so as to get into the food security. So the appropriate government shall specify when it is going for this, that is acquisition of any such land which is an irrigated land, then the appropriate government should very clearly specify the extent of the land in percentage, I am speaking, extent of the land what he is going to be acquired with, and what is needed to be the project, and out of which the total land which is needed to the project, out of which those land, what is the land which are a cultivatable land should be clearly described in its acquisition process or in its acquisition proceedings. However, my friends, this act of having specifying that these are the lands which are required in, that is, it has to specify all these things. The percentage of land is to be specified, and also giving an equivalent land is not applicable to the cases where if that land is used for a linear project, or where that land is used for the purpose of infrastructure or for any other minor projects as concerned. If that is necessarily to be required with, then in such cases, my friends, we shall see that the government is exempted from doing this. But otherwise than this, the government, when it goes for an acquisition of land, it has to take this into consideration, look into the food security, and looking as to the food security, then the government shall proceed for the acquisition of this land. So this is one with respect to the land acquisition, which also considers that when you are going for any acquisition, especially with the agricultural land, the two where that agricultural land is used for the purpose of irrigation, or where vast irrigation has been, or complete irrigation, or multi-cropped grains are being made, or multi-cropped patternly, in a pattern of multi-cropped, if they are growing an agricultural producers, then they should be taken as a last resort in order to have a food security to that of the nation. So this is one restriction that is imposed in respect of any land acquisition proceedings. So after having discussed with this land, that is land acquisition, has to give a due regard or due concern to the food security, then comes is the preliminary notification. Preliminary notification under section 11. Friends, as a preliminary notification, we would be discussing with the powers and also the functions as how the officers would go in respect of preliminary notification. Even while addressing on this preliminary notification, we do understood, like when I was discussing to a procedure of acquisition proceedings, we came to understand that the very first stage, that is after the government proposes for the acquisition of land in a particular area or in a particular survey numbers, or if the land is required, if the government wants to say that this is the place wherein the land is required for the purpose of the proposed project, then the first and foremost thing, I can say the first stage is that the government has to undertake, appropriate government, again I repeat this has to undertake a SIA study, social impact study. This is the first stage. And at the second stage, we shall see that the experts group should also involve in studying upon and make a recommendation to that of the appropriate government, and having made an appropriate recommendation and report to the appropriate government, where if the appropriate government is satisfied to the effect that the land is required for the purpose of the public, or it is for the development project or any projects that which I have spoken to you in my previous audio, we shall see that the third stage comes is the preliminary notification. That is, if the government is satisfied saying that this lands are required or this amount of land is required for the purpose of the said project or for the purpose of said concern, then having satisfied with that, that is having overall study of this, even including SIA and all the other expert studies, even in SIA, satisfying to those requirements, then the government proceeds for issuing this preliminary notification. That's why we say, wherever where it appears to the appropriate government that in any area or in any village or in any town or in any urban areas or rural areas, if the land is required for the public purpose, then by notification to that effect, which we call it as preliminary notification, to that effect they can give out the details of the land which is going to be acquired both in rural and urban areas. And once when it is being given in rural and urban areas, that is when they go for a notification both in urban and rural areas, they are also required to comply certain things here. The first compliance is they have to state or they have to notify in their official gazette. Having notified in the official gazette, they are also required to state the same thing in the 2 daily newspapers circulated within the locality of that area where it is being done or where acquisition is being done, and that too it should be in the local language. And also a part of this, that is after having given 2 publications, newspaper publications, that is a part of having stating it in the local language, and the same local language they are also required to state the same to the panchayats, to the municipalities or municipal corporations, as the case may be, that with respect to the acquisition of land. And in addition to this, my friends, the same notification shall also be notified at the notice board or at the office of the district collector or subdivisional magistrate or even the Tahsildar. In all these 3 places, they have to notify with respect to that of the acquisition of land. That is, the notification has to be uploaded, it has to be notified in the notice board in this regard. And leaving apart of all these things, it goes further, the new act goes further and says that in such cases, my friends, it is also required on the part of the government, that is appropriate government, to have a separate website for this. And even in that website, they have to upload of whatever the acquisition process is going to be carried upon with. And it should also specify those things, and it should also bring into the knowledge of all those persons in the affected area in such manner as that is being prescribed with. So these are the primary works that what the appropriate government has to undertake in respect of that preliminary notification. And apart of this, we shall also see, as the part of this preliminary notification, that is immediately after the notification is issued by the appropriate government, the concerned Grama Sabha or the Sabhas at village level or municipals and municipal areas or even the autonomous council, as we see under the 6th schedule of the constitution. All these bodies should be informed with the contents of notification. I repeat, I was saying you, they have to be given an advertisement, they have to be giving a notice. But apart of this I am speaking, they have to be notified and they have to be informed with the contents of this notification. In all cases of acquisition proceedings, my friends, they have to especially hold a meeting for this purpose. They have to hold a meeting in the concerned area, in the concerned level or in the concerned places where the meeting has to be called in respect of the process of acquisition. And the notification shall also contain a statement to the effect that the nature of public purpose for which the company, that is which the government is going to acquire upon with. That is, the only reason is that the people who are going to be affected, that is what we call it as affected families, the people who are going to be affected or who are going to be displaced from that of the place or affected persons shall also be given with the SIA report, particulars of that SIA report, and the administrators who are being appointed for the purpose of rehabilitation and resettlement under section 43. You have to give out all those particulars. That is, when the meetings are being carried by this government, they have to satisfy even with section 43 also. This is the requirement they have to undergo. And the fourth requirement is that no person shall make any transaction. Restriction is imposed there. No person shall make any transaction in respect of any such land which has been specified under the preliminary notification. That once preliminary notification is issued, that becomes a restriction, that a restriction would be imposed against such owner of that property from having dealing with the property. That is, he cannot alienate or he cannot transact any such kind of interest in respect of the property. In a simple word, I can say you in this way is that is, after such preliminary notification is issued, he cannot, that is, such owner or such interestee in the land cannot create any encumbrances in the land from the date of which the publication or such notification has been made, and or from the on such time as it is been notified and this or the notification is said to have been completed. So nothing has to be made unless where if the concerned owner can make an application to the controller seeking upon the controller for the purpose of having permitting him to go with a disposal or alienation or transfer of interest. That is, he has to make an application, and the collector under a special circumstances, that too by recording in writing, if he is satisfied to this effect, then the collector or in a deputy commissioner, whatever we say here, shall have a power of having granting an alienation. And such cases, the collector or deputy commissioner shall also look in that no loss or injury is going to be suffered from the act of this, or there would not be any willful violation of any of the provisions of the Land Acquisition Act. So subject to these things, we can see that the land can be allowed to be transferred after the publication. But once otherwise than this, once when the preliminary notification has been issued, there is a bar on the part of the interestees or the owners from having transferring the property. So there is a restriction to this in such a way. So once when this preliminary notification, that is after the issuance of notice to all such persons who are interested, the collector shall issue a declaration. I'll come back to that later, but anyway, the collector shall issue a declaration under section 19 of the Act. That is, you would be undertaking to complete the exercise of the acquisition proceedings. So to this effect, that is, after a declaration is been made, the same shall be updated in all those land records within 2 months of the day of declaration. So this is the one we can say as what would happen in case of preliminary notification. This could be asked for your short notes, or it could be taken as a main question asking you with the other parts of your discussion, what we are having to do now with this. So once when preliminary notification is there, in fact, he has to satisfy with all this criteria. And having satisfied with all this criteria, the next comes is the damages. Suppose in the course of this, if any damage is being caused, then they shall also undertake to pay the damages. And in fact, section 14 of the Act says that, see, there is a SIA report. Basing on the SIA report, the preliminary notification is going to be issued. Then once when preliminary notification is issued, then within 12 months of time of the day of which preliminary notification issued, from that day within 12 months of time, they have to proceed in making a declaration. I repeat this. See, SIA study is being made. Having made an SIA study, within 12 months of time, they have to undergo for issuing a preliminary notification. And then they have to proceed for a declaration. Of course, for declaration, it may take little more time. But once when SIA has been made, report has been given to, within 12 months of time, you have to issue a preliminary notification. If there is a failure on your part to issue a preliminary notification, then all these proceedings becomes lapsed. Entire proceedings becomes lapsed. And again, if the government wants to proceed to a land acquisition, again they have to get into SIA study, that is assessment study they have to make, and then again within 12 months of time they have to go for the acquisition proceedings of the second SIA study. So if you have failed to go with this, then that is the end, it lapses out with. However, if at any time if the appropriate government finds that it cannot be satisfied within 12 months of the SIA report, then it can extend this time for further period of 12 months, not more than that. So in all together, actually it is 12 months of time, but apart of 12 months, it can go further in providing additional 12 months only with the prior sanction of the concerned government. Otherwise, no such extension has been provided with. So in this way, we shall see that the preliminary notification is going to be issued in respect of the acquisition process. And what we understand from this preliminary notification, friends, the procedures you know have already in the quiet time I was speaking to it. When you look at with this as how this preliminary notification and what would be the sense of this preliminary notification. In fact, friends, once when preliminary notification is issued, I can say you that we can understand in this way, it is a signal given by the government in respect of your acquisition of the land. Of course, till SIA study, it is only a study. Whether the acquisition would be going or not is not confirmed with. But once when preliminary notification is issued on your part, it is understood that it is a signal given to you or to the public with respect to the acquisition of the land. And where once when this preliminary notification is issued, the government which it intends to occupy the land, if it is doing that, then it also a way I can say it is an intention shown by the government to occupy the land by issuing a notification in this regard. That is by giving it, by specifying in the official news gazette, newspaper, and also specifying in the official gazette which is situated in that locality. So by doing that is what we say, it is a beginning in all acquisition proceedings. We can say that issuance of preliminary notification is the first step which the government is going to take in respect of entering into an acquisition proceedings. That's the reason why it says that a notification shall be made. That's what I was saying to you even just before. That is, at least in 2 daily newspaper, the notice shall be served, and also the notice shall be made upon to all those persons who are residing in that vicinity or within that local area. So in this way, we see that the notification has to be issued with. And in fact, in state of Gujarat versus Pancha of Nani Amam's poll, 1986 Supreme Court, my friends, I repeat this, state of Gujarat, it's just an observation, state of Gujarat versus Panch Nani Amam's poll's case, the Supreme Court made it very clear that the personal services of notice to all such affected person is not contemplated under Section 4, Class 1 of the Land Acquisition Act 1894. Because it was a previous case, I'm just saying you on this. It said that personal services of notice to any such person will not say you that the notice is being served upon to the person. And what the Act says for is that it says that at least 7 days before of making this notice, there shall be a public notice issued by the government. At least 7 days before, and there shall be a public notice, and no personal services are being allowed to go with. So this entitles for an officer, that is by issuing this public notice, it entitles to an officer to enter into the land, to dig out the land, to set out the boundaries, that is what could be going to be acquired with. It gives an opportunity to all this officer to do such act in this regard. So that's why it becomes necessary that this notification and notice to that of all those person is compulsorily required with. And I can also say you that is by issuing this notification, preliminary notification, it gives the government entities, officials to investigate into the proceedings and to ascertain with the necessity of the land, and also to look down the suitability of the land in the process of its acquisition. And once when preliminary notification is issued, the owner cannot condone, or sorry for taking the word condone there, cannot condemn the act of these officials, or cannot obstruct the act of these officials, or cannot restrain the acts of officials in entering into the land, marking of boundaries, etc. with this. However, a small ample relief is been provided, which says that is, if in case while at the time of entering or while having marking, if there is any damage caused to that of the property of him, or adjacent property of him or of any other person, then the same can be claimed for that of the damages what is being caused to. So only to that extent, my friends, we can see that the owner has a right of restriction, but otherwise than this, he don't have a restriction once on preliminary notification is being issued. However, again I can say, see, once when such preliminary notification is issued, in case of insufficiency of the amount as what has been contended by the appropriate government, then on such insufficiency of the amount what is going to be distributed as a compensation amount, can once it is being made out, the decision of that could be challenged to the collector, that is before the collector, as to the reference of the payment of compensation, or to the chief revenue officer of that district, whoever who has been authorized then. And the decisions of this collector or the chief revenue officer shall stands to be final, and no suit or no claim can be entertained against such decision of the collector or the chief revenue officer. That becomes the final in nature. That is, if I have any dispute with respect to the insufficiency, I can go challenge them, and before that challenge, and with that challenge, the order so passed becomes the final in nature. However, if there is an amount of damages, if the amount of damages itself is not accepted, or if the compensation is not accepted, then the same shall not be included. As such, we can say that there is still a pendency in that, and if the same is accepted, damages is been accepted, then the collector or the chief revenue officer shall have a right to pass a final award in this regard. And once when the final award is being passed, the same again should be uploaded in the website, the summary along with the summary of SIA, particulars of the administrators who are being appointed, the damages so awarded, and also disposition of what is being made in this regard. So with respect to all this information, the same shall be notified in the website. So in this way, my friends, we shall see that the person shall have, that is the appropriate government can proceed in issuing a preliminary notification. And once when preliminary notification is being made, as I was then speaking to you, the award is going to be made. When I say award is going to be made, a compensation is going to be paid, to whom it has to be paid? See, the very first question comes is that when preliminary notification, the entitled should be, that is the entitlement of this award, or any entitler shall be entitled to the award only when he establishes his interest in it. So it becomes necessary for us to understand what is this person interested. I have written here public interest. I am not to say that public interest, but it is persons who are interested. person interested. So only where a person who are interested, he is entitled to have a right to compensation or right to that of the award. So this being the fact, it becomes necessary for us to equally understand while having issuing a preliminary notification, while having issuing the award, we should also require to understand who is this person interested. Friends, section 15 clause 1 of the current act or the 2013, that is new enactment, says like this, that is, once when the preliminary notification is issued, within 60 days of its time, in writing, the person, that is after the publication has been made, that this person, that is person who is said to have interested, has a right to raise an objection in this regard. In fact, the previous act spoke upon with 3 months of time, but the current act speaks with 60 days of time. The time is being reduced probably by another 30 to 32 days for that matter. There it was only saying 3 months, but now it says that it is 60 days. So within this 60 days of the publication, preliminary notification, then this person is having a right to go for having raising an objection as to the compensation of acquisition that is going to be awarded, or as to that of the land which is going to be acquired with respect of public purpose, or even with respect to the payment of that compensation to the person who happens to say that is interested in the property. And in that cases, it is necessary to need to know that who is this person interested. How can a person said to be have interested? In fact, section 3 clause 1 subclass 10, I'm speaking Roman letter 10 of the act says like this, or defines the term public person interested as, is a person who is deemed to have an interest in the land. I repeat this, deemed to have an interest in the land, or who is entitled to claim an interest in the compensation to the land what is being acquired with. So any person who is deemed to have an interest in the land, or any person who is having a right of payment of compensation, then such person is said to be called as person interested. This could be also asked for your short notes, my friends. Person interested can be also asked for short notes. Very important from the point of examination too. And we should necessarily require to understand who is this person interested. I like to take and establish with the 3 illustrated case here, the case laws here. One is in case of Bhairavamurthy versus M. Venkataraju, 2001 Supreme Court, where the court makes an observation in this regard and said that, or held that, the term person interested has been given a very broader meaning, and the situation warrants in seeking that a person, it also includes the person who happens to have an interest in the easement of that land. If a person happens to hold a easementary right of that land, can also be a person who could be considered to be as a person who is interested in the land. So in a general understanding, we will say that it is the owner of the property, or any person, the mortgagee of the property, or the lessee of the property. This person would be having a right. But otherwise it says, when I say deemed to have an interest, the court said that is even a person who happens to have an easement right over the property shall also said to be called as a person who is interested with. This is one observation what the court gives in. The second observation, that is in case of a very remarkable case or very landmark case, I can say, that is in case of Andhra Pradesh Agricultural University versus Muhammad Unisab Begum's case. The same Supreme Court, that is full bench of, not the Supreme Court, sorry for that, it is the full bench of Patna High Court, have come up with this ruling that it has In fact, when the Patna High Court have given this ruling, it has also looked down to the several decisions of the Supreme Courts have passed then, and relying upon that several decisions of the Supreme Court, it held saying this: the person interested does not really mean to say a person who is a really interest in the property, or who wants to have a real interest in the property on which the land is sought for the acquisition. And it proceeds further saying this: it is even enough that if a person claims the amount of compensation in it, or if he establishes to show that he is entitled for a compensation, then that person would also have a right in respect of the property. He can be called as a person interested with. However, there shall be a distinction from the interest in the property and the amount of interest what is being sought. That's the reason why the court said saying this, that is, it made its observation saying like this: a purchaser of the land would not become a person interested on this ground. That is, he cannot say that he is deemed to have an interest in the property. Suppose, say, if I have entered into an agreement with a purchase of land, and because merely that I have entered into an agreement for purchase of land does not give me a right to have a right of interest in the land, or I can only seek for is that for an additional price, for because of the price that whatever the advance money or token money that I have been paid, only to that extent I may have a right, but not a right in respect of the property. So only to this effect it said that no, it does not have a right. So there the court made a distinction saying that who can be a person who is interested in. And in another case, that is in case of Amar Singh Jadar versus Shanta Devi's case. In this case, the court making an observation to extend the scope of the person interested, it said that a person who is in possession of a property is a prima facie evidence to show that is entitled to the compensation. I repeat this: a person who is entitled to the possession, or who is in the possession of a property, is a good evidence to show that is entitled to the compensation. So this person can also be considered as a person interested, whether he is in the occupation as in the capacity of a tenant or licensee or whatever, or a mortgagee, whatever it is. This is immaterial. It is immaterial to this effect, but it says that he is entitled to. So these persons have a right within 60 days of time to make an objection in respect of any such notification that is being made. And when the objection is being taken, how should it look up with? That is, how personal hearing of objection has to be made. Section 15 class 2, as I then said, it provides for this person interested to make an objection on this land, on the acquisition of this land, and he can present his hearing, that is, he can seek for his hearing in the acquisition proceedings. Otherwise, the whole acquisition proceedings becomes invalid in nature. That is, right from the inception, if the person interested has taken an objection to this, the bounded duty is to hear upon him and it has to decide upon with. If that is not there, it becomes invalid in nature. So in such regard, when an objection is taken, the collector, after making a due inquiry, frame a report of this and forward it to the government for its final order. In fact, the hearing by a collector is said to be considered as a quasi-judicial body. It is considered to be as a quasi-judicial authority. It is of a quasi-judicial nature, while having hearing and drawing its report in respect of that objection what is being right. And under section 15 class 3, it says that when such report is being made to the government, the appropriate government on the report of given by the collector may come out with its final report, and that report the order what is being made by the appropriate government stands to be final in nature. And it also says that this can be made and it is applicable only to that of a person who is interested in, or I can say the decision of the appropriate government is final as against to the objection with respect to the persons who are interested in, and it is in pertaining to that of the acquisition. And the main advantage, I can say, my friends, of this inquiry, that is by the collector, the main advantage of the inquiry is that that's what the Gujarat High Court, a full bench of Gujarat High Court has assessed with this, has what would be the benefit of this hearing. That is in case of Patel Gandalal Somanath versus State of Gujarat. In this case, I repeat, Patel Gandalal Somanath versus State of Gujarat. In this case, the full bench of the, or I can say, I don't say full bench, it is a bench of the Gujarat High Court, because full bench comes in High Court, in Supreme Courts, my friends, sorry for that. Then it said this, that government can decide whether that the particular, that is by hearing upon, at least the government can decide upon that whether the land is needed for the public purpose, for a company or for PPP or for, that is, public purpose. So a due inquiry enables a person who is interested in to show that the acquisition in question is not serving the public purpose. So only when you have satisfied with this, then it provides the government to go with. That's what section 5 capital A provides with. So after the collector's report, the government can make a declaration to this regard. However, this declaration shall be made within 12 months of time. That is, after having made a report by the collector, the government, that is from the day of preliminary notification, all these things should be carried, and within 12 months of time, my friends, we shall say that the notification can be made by the government. That is, it can make an order in respect of the same for whatever the objections that is being taken by the person interested. And mind this, or I would like to remember you here, that is declaration, that is after having doing this, finally the appropriate government shall go for declaration under section 19. So the declaration under section 19 is mandatory on the part of the government. It is a mandatory requirement. Without having making a declaration, then the no acquisitions is complete and no acquisition can be made. And even in providing the declaration or effecting a declaration, making a declaration, it says that is the government cannot proceed to do this declaration unless where the payment of compensation, whether in part or full or in installment, or at least one installment in such case, has been made to that of the person. And the failure to give on the give an hearing when such objection is taken by the person, that is person interested, also make it has a fatal in nature, which would wholesomely, I can say, it invalidate the proceedings of the acquisition process. But a person who have no right to, or a person who has no right of interest, or I can say you in this way, a person who himself has no locus standi to or question upon with, has no right of this objection. And you should also understand here, my friends, once one's objection is being taken by the person interested, and if it is being decided by the government, then there is no second opportunity. There is no second opportunity. Again, I cannot come before challenging upon the same issue of this. However, as I was then also saying in my introduction class, that in cases of urgency, where the land is immediately required for the purpose of urgency, then in such case, my friends, this class can be dispensed with. So except of this, my friends, everything or every such thing is to be followed while in case of the acquisition proceedings. And we also see this, my friends, by that of several case laws we have come across with. We have come across saying that, or by the executive instructions that has been issued time and oftenly in respect of the land acquisition by the state government, we have come across that there are certain objections which can be taken up by the persons interested. And what are those objections? I can say, I can give you few list of objections which can be taken out with. The objections, it could be also asked for the as for your examination, like what are the objections that can be taken in respect of the land acquisition by a person interested. A very small answer for that matter, but you have to add out all those things while answering this. See, what are the objections? As we have few of them we have already discussed to it. One is that the first kind of an objection that he can take is that he can say that one's land, if my land is there, if that is my land in the sense, I'm saying using in the word has, that is one's land is not needed or is not suitable for the public purpose. This is one objection he can take. That is the grounds for an objection for that of land acquisition. That is, my land what is going to be acquired is not necessarily required or is not suitable for the public purpose. One. The second one is that the project which you are undertaking to with is not at all a public purpose. It is not a public purpose. Second objection. Or the third one is that the land what you are going to be acquired is more than the land what is being required in respect. That's what we can see when NICE project was being brought in. Several such cases was made in Bangalore. I'm speaking when NICE corridor project was brought in, there was lots of litigations made before the court saying that the land what is being going to be acquired is more than what was required with. So where more land is being acquired than necessary. The fourth one is this. Commonly, very rarely we come across with this ground. That is the acquisition. That is this acquisition by the government will destroy the property, something like it would destroy the historical monuments or places of history, or that is in the public interest it becomes necessary, where it would not be to the benefit of the public, or also, my friends, it is the common objection which every public would take if it is an public action is that is the religious institutions are going to be destroyed with. So in such cases, of course, when it comes to the religious institution or religious buildings, the courts have come heavily on this and said that mere a religious institution cannot itself be a ground for an objection unless where there is another option left to the government to have an acquisition proceedings. But merely I have a temple there, merely I have a mosque, merely I have a church in the road or in the area does not take away my right. But of course, this can also be a one ground stating that there is a religious building which is being made, or religious building is that is going to be dismantled, or it is going to be destroyed, or whatever. That can also be a ground for this. And without an objecting to the acquisition proceedings, my friends, there can be no right. Suppose say, without making an objection to that of the land acquisition, in any of these form I'm speaking with, without making any objection to this effect, I cannot come before the authority stating that or taking an objection that my name is not being included. I shall have a right. That's what I said to you at the beginning also of this discussing. I shall first establish a local standard. If I come out with the omission that my name is not there in the list of persons who are interested in, or the particulars of the land what is being given, then I have to show that I have a right of objection of any of this. So only then I am given a right to go with. Or also the other objections I can say is that where the objection what has been taken or what is being looked in and the compensation which has been awarded is at the very low quantum amount. This is one objection, common objection which we see. On all these grounds, my friends, we shall see that the objection is being taken. See, as far as when I was speaking to the first, second, third and fourth kind of objection, it is very difficult to exactly prove upon with or to establish upon with. That is, without knowingly the exactness of such land, I am unable to go upon with. But when it comes to the fifth kind of objection, this is a very common objection which everybody would take while having an objection to the land acquisition. And my friends, where if the land acquisition is for the company, they may also ask you a question saying that how land acquisition has been made in cases of company. Very simple answer to this, need not have to, because even in books when you go, it is just a para of it is being given, about 5 to 6 lines it is being given to with. So that makes little brain scratchy or head scratchy for you, like what to write when it is asked for 10 marks or 16 marks. You have to. And nothing new there. See, we have discussed all through this as what has to be done. The same thing complies here, because what I like to say here is that the current, that is the new enactment, does not make any different procedure in respect of an acquisition for the land for public purpose and acquisition of land for the purpose of company. It makes no distinction. The procedures are same. Every land that is going to be acquired for the purpose, that is public or PPP or for the company, they have to undergo with all these procedures what is being laid down with. And one addition to this is the act prescribes is that for rehabilitation and resettlement of the affected persons. That is, after having paid the compensation, if the persons who have lost their living, who has lost their houses, for the purpose of rehabilitation and resettlement, a part of the compensation has to be undertaken with. So in addition to this, we shall say that the purchaser shall undertake the rehabilitation and resettlement, provided it says that where if a land is acquired, especially when it is a case of a company I'm speaking, that where a land is acquired to an extent of 50 acres or more than 50 acres of land in urban area and 100 acres of land in rural area, 100 and more acres of land in rural area, then definitely apart of paying the compensation, they are also required to have a rehabilitation and resettlement of those person in addition to the compensation. Of course, my friends, when I'm discussing to you with this rehabilitation, I'll be discussing to you on my later part of my discussion here. But this is how we see that the notification, that is the proceedings of acquisition takes place. And as I was then saying to you, with this declaration of the notification under section 19 is necessary. That is, where after satisfying all these criteria, if the central or the appropriate government finds it suitable that land is necessary for the same, that is for the project of which it is being made, then it can proceed for declaring the land for its acquisition and to give an effect for this acquisition. My friends, in fact, when the government goes in for declaration of that land, then it shall identify that what shall be the area of resettlement when it is falling under this. It shall identify the area of land where the resettlement is going to be made or to that of the affected families. And in fact, we can say this, that this declaration of land, that is declaration of notification, not the land, sorry for that, declaration of notification under section 19 is the conclusive proof of evidence to show that the land is going to be acquired with. It is the conclusive proof, and the publication is also equally necessary. That is, once when preliminary notification is issued, in the previous enactment we used to call this as final notification. Here people, because of its practice, we still call it to be as a final notification, but it is called to be as declaration of notification under section 19. The words taken now today is declaration of notification. We don't find much of the difference with that of the final notification than which was used in the previous enactment. And what is this they are required to do is that is they have to make a publication of even this declaration. That is, under the new act, it says publication of declaration has to be made with the land acquired for the public purpose, whether it is for the public purpose or PPP or for the private company. The same thing again carries with the same routine procedure it goes with. That is, the same shall be notified in the official gazette, the same shall be notified in the 2 local newspapers, and that having made out, that becomes a conclusive proof of evidence. And it is also, my friends, we can say it is a proof of evidence to show that the land is being taken away. So, acquiring of land is, the proceedings of acquiring the land is being put into motion. And taking an order of this acquisition of the land, the very next step is this, my friends, the process of acquisition starts with. That is, marking out of the land. It is the duty of the collector to mark out the land, and and even when a collector goes for marking out of the land, no obstructions can be made on this. And if any person goes in for an obstruction of an entering of any officers into the land or anything such an act is being done, then he can be imprisonment. He can be imprisoned. Such person who is obstructing can be imprisoned for the period of not more than 1 year of time. So that is also provided under the Act. So this is how, my friends, we shall see how land acquisition proceedings goes on with. The next comes, of course, I'm skipping some of the in-between provisions because it would be, it speaks upon with the rehabilitation and resettlement, but when I come there, I'll be discussing to you what is rehabilitation and resettlement, and there I'll be also discussing to you with the authorities or administrators of rehabilitation and resettlement. But for this matter, I can only see you is that we shall see that the land which is acquired shall be taken into after the declaration has been made effect. In fact, section 24 provides that the land which has been published with, the acquisition process shall deem to have been lapsed in certain cases, where it says that in a land acquisition proceedings, it is the duty both under the old enactment and the new enactment. It says that until and unless no award is being made, or if you are not following the provisions of the new act, that is new act is applicable. If you are not followed any of the provision, then we shall say that the acquisition process get lapsed with. That's the reason why it says that is where an award has been made and the proceedings has been initiated in this award, that is after the commencement. If you have failed to go with this, of course 2000 bill is been pending in this regard. There is some changes which they are willing to bring upon where. See, it says that where if an award is being made and this after 5 years of time of the commencement of this current act, or where the physical possession of the property is not been completely taken upon with, is not taken with, or any act of taking the physical possession has not been made, even in respect of the 5 years of lapse of time of this award, then once when there is a lapse of this, the appropriate government loses the right of its acquisition in that of the land. But today, the 2015 bill is of a saying that you have to give some relaxation to this of 5 years. They say that suppose if this, because the new enactment never said anything, within 5 years of time you have to satisfy with all this criteria. You have to take a step, at least a step in taking the acquisition of that land. If you don't do, then you lose the right. But now the bill seeks saying this. Of course, it has not been brought into force. The 2015 bill seeks saying this. Look at this. You cannot just abruptly say 5 years of time. If you want to have 5 years of time, then please deduct of those areas. That is time taken in the litigation of having deciding, maybe with respect to the awarding of compensation it could be, or insufficiency of compensation it could be, or in determining the person who is interested as to whom the compensation amount has to be paid. In respect of these things, the time taken for this should be deducted from out of this 5 years they are seeking. Of course, it is genuine claim that what some of the people or some of the luminaries are thinking upon with this. It is do right with this. So subject to this, my friends, it is said. So what it says is that when the award has been passed in this regard, the award shall, that is after the award, it shall take the occupation of that land and it shall proceed in acquisition, or it shall proceed in acquisition proceedings. And it also says like this, where if in passing this award, if that award does not represent the market value of the acquired land, please underquote. Now I am coming to the market value. If that does not represent the market value of the land, then again a protest can be filed in this regard. That is, the persons who are interested in can make an application, and of course I was saying you as one of the objection he can take then. The person who has interested in can make an application before the collector to refer this matter to the civil court for determining the market value of the land acquisition. I repeat this, the tribunal has a power, but when it comes to the determination of the market value, you can seek the collector to refer the matter to the civil court in determining what is the market value and how market value, that is with the determination itself, if it is not correct, then they can go for even before the civil code. So how is this market value be determined? Section 26 speaks upon with this. How market value is going to be determined upon with. And there by virtue of section 26 adopts the following criteria or certain criteria in assessing or determining the market value of the land. Something like 1. See, 1 is, it would always look down what is the market value that is being specified under the Stamp Act 1899. That is the place or the vicinity of which the land is situated. This is 1. That is, by the land value what has been given under the Stamp Act, in terms of the value what is being specified under the Stamp Act, the market value is assessed. The second one is the average sale price at the nearest vicinity of that land can also be considered as a market value. That's why what people do is that people go whenever an acquisition comes in, that is the recent sale which has been taken place before the publication is being made. They'll try to get those sales what has been made within the vicinity of that area. So that if the market value is 3,000 for that matter per square or per square meter or 30 lakhs of rupees per acre of land, if that is the situation, then they can go look into finding out that what is the sale that has been taken place in and around the vicinity of that area before the preliminary notification is given. Suppose if in that area, if they come to know that there is some sale which has been taken place or agreement which has been entered into, that the sale is going to be effected for 40 lakhs of rupees per acre, then that can be taken as a market value. That's why it says that the average sale price in the near vicinity of the area shall also be taken in determining the market value. Or where if the land is going to be acquired for PPP or private company, and if the PPP or the private company has consented with these parties or consulted with these parties, and the parties have consented to certain compensation money for which the company have accepted to pay upon with, whichever is the higher in that case, that would be taken into consideration. Mind this, the date of market value is always taken just before the date of notification, not today's market value, not today's day of which it is being made. The date of which the notification is issued. So before that date, what should be the market value would be the value what they are going to be taken with at the first instance. And in calculating the market value, they can calculate the market value as specified under the first schedule of the Act is concerned. That is taking the consideration of those which is being specified in the first schedule. And the third criteria is that where the market value under, as I then said under subsection 1, what we have speaking with, if it cannot be determined for any reasons like, see, sometimes in all this basis we can say what is the market value, and in terms of calculation under the schedule 1 we can decide this would be the market value and the payment of compensation can be made. For some reason it cannot be ascertained also, like say where the transfer of any such land in that part of the area was restricted, and any law or such law for the time being in force has not specified for the transfer of land in that area. Now, how do I take Prevention PTCL Act? See, if no determination can be made in that area, or where if there is no registered agricultural land similar to that of this land which is made available with, that cannot be made out with, or where if the value of that land is not specified under the Stamp Act. So in these cases, probably we can say that we cannot ascertain exactly what is the market value of that. So when it is not possible to determine what exactly is the market value, the state government concerned in this regard shall specify the price or minimum price per unit area or price of unit area of the said land based on that of the price calculated in any 1, 2, 3, 4. On the basis of that, the state government shall have a power in this to determine what shall be the market value of the land. And the requiring body in this case also shall also compel the owner of that land to take up their shares and value of which is ordered with or which is made with, and according to that of the deductibility what is to be allowed, and it is to be calculated with. So the collector in this regard, before having passing an award, he shall make an intention of land acquisition proceedings in that area, take all those necessary steps to review out those market value, that is before the publication is going to be made, because after the SIA report comes in, I can say in a way it is a clue for a kind of acquisition in some cases, I can say, because what the collector normally do is that before he could go for a preliminary notification of acquisition, there would be a revision, overall revision of in and around areas of where the acquisition process is being made, and he can determine what shall be the market value. So on the basis of that market value, we shall see that the acquisition process is going to be made. And in respect of this, my friends, section 27 speaks with the determination of the amount of compensation. The collector shall have a power of determining the market value of the land. He shall have a power to calculate what shall be the total amount of compensation to be paid to that of the landowners, including the assets what is being attached to that of the land. And of course, in calculating this, the collector, in having passing the award, he shall also go down to certain parameters for determination of this award. One is that he shall determine as under section 26, that is how the market value is going to be calculated. That is, he shall look down to section 26, determine what is the market value, calculate in terms of schedule 1. If nothing is being provided, the state government has a power. So on the basis of that determination, they can go for deciding what is the market value. The second one is that if any damages is being sustained, maybe while entering into or while breaking opening of the purpose of the acquisition for marking of the land, if any such damages is sustained thereto to the person interested, then the collector shall, who is getting into the land or taking the possession of a land or acquiring the land, if it has caused injurious to that, affecting to that of the owner's property or anything as such, then what is the amount of damages that would have caused by them shall also be taken into. And the collector shall also take that the person who is interested at the time of taking the possession. That is, when he is acquiring the land, when he is taking the possession of the land, he shall also give due regard to such persons who are interested in for the reason of securing the land or others' land for that matter. And if through the course of acquisition, if that has resulted in a change of any residence, maybe it has compelled a person to have a change of his place, change of his business, so on and so forth, that shall also be taken a due care in respect of that acquisition. And the damages what is going to be made shall be a bona fidely resulting out of a diminution of his profit. Suppose sometimes say I am a good businessman and I have been there for several years here, and today if I am going to require to be, or I am compelled to shift from this place to another, definitely I may lose my profit. I may have a diminution in my business or in my existence of residence. So whatever the diminution that takes place in course of acquisition shall also be calculated and shall be declared at the time of awarding the compensation or taking the possession of the land. So all these are the criteria, and of course, as we see, because we are following the common law principles, it says that is any other ground of which in the interest of equity and justice too, if the collector is satisfied, that he may pass such an award to that of the affected families. So in this way, my friends, we shall see that the value can be assessed. Otherwise, then this even section 29 provides for the same, that is determining of the value at the time of the acquisition is that with respect to the attachments. Like if the assets has been attached with the land, building or any equipments to that of the land, the engineers who are competent enough to have in this, or specialists who are competent enough in this relevant field can make a necessary analysis, or they can make a necessary loss which is expected from that of the acquisition can be made by them. If there is a plants and trees that they are grown in, for which it is going to be destroyed out with, maybe the Department of Horticulture or Sericulture in the concerned field can be called to analyze what is the amount of damages that is going to be caused. Or in case of a standing crop is concerned, my friends, it says that is an agriculturalist, a well-known agriculturalist in this area, an experienced person in this area can also be called for analyzing what shall be the loss that is going to be caused upon with this. That is, basing on this, my friends, we shall see the collector shall be passing an award. There can be a question on this as how the collector, what is award and how what are the procedures that has to be followed while calculating the award. I repeat this, what is award and what are the procedures that is required to be followed in calculating the award is one such question which they can ask you for the examination. So you can concentrate on these areas. And of course section 30 is also there. See, when I say award, it is not just paying you the market value or what is that is lost in that, or otherwise than what you are going to be compensated for the loss of damage what has been caused to that of your property. But in some cases, we shall also see that the award shall also include a solatium amount. Kannadalli nashta bharti anta ನಾವು ಹೇಳ್ತೀವಿ. It shall also include a solatium amount. That is, where a collector, after having determining the total amount of compensation that is going to be paid on this, then my friends, he can also impose a solatium amount that could be paid upon this compensation to the extent of 100% of the compensation amount. I repeat this. He can pass an order or pass an award of having granting the solatium amount in spite of the compensation what is being made to the extent of 100% of the compensation amount. That is, where the collector finds it necessary, then he can issue to an individual award detailing about the particulars of compensation that is going to be paid, details of payment that is being paid in respect of first schedule, and in addition to that of the market value provided under section 26, the collector shall also have a right of paying the compensation, that is solatium amount, including 12% of the interest payable on that compensation. So now look at this. See, how is the market value taken? Market value is taken till the day of the preliminary notification. But from preliminary notification to the declaration of preliminary notification and passing of an award in this regard may take time together, maybe 6 months or a year or 2 years, sometimes it may even go for 3 years because the maximum time is given 5 years. So within this 5 years, the government has a power to satisfy and proceed for acquisition. So if any time that is being taken with, the collector shall have a right even to pass an interest on that regard at the rate of 12% per annum of the market value, that is the period commencing from the date of publication of that preliminary notification or with that of an SIA report or SIA study what has been initiated. So to this effect also, my friends, we shall say that is the collector shall have a remedy to go upon with. So in this way, the compensation and award is going to be made, and once after all this is being done, my friends, that is having satisfied all these criteria, after having putting out the award, payment of the award, whether it is in part or in full or in a equal installments has agreed upon, there would be a completion of acquisition is made. But it says that the completion of acquisition is not necessary in certain circumstances. That's what section 93 speaks upon with this also. Of course, I'm just dropping to section 93 from 30. It says that at any time of this proceedings has been taken place, if the appropriate government finds that this land is losing its sanctity with respect to the public interest, or if it finds that at any time it finds that even after a SIA report, if it finds that no, this land is not necessary for that of the purpose for which it is going to acquire with, then it can give up its right in respect of those acquisition. That is, before the compensation is being made, it has a liberty to withdraw such acquisition proceedings with what it is proceeded with or what it has carried upon with. So the collector in such cases shall also determine the consequences of damages that is being suffered by those person in the course of all this act. In the course of all this act, and shall also determine what shall be the amount of damages that is going to be paid to that of the person. In that case, the government can withdraw the proceedings, acquisition proceedings, before the possession is being taken, or where the award has been made and award has been paid upon the person on the notification, realizing that the land is not required for. Afterwards, the withdrawal of the acquisition proceedings, my friends, even the government for that matter is prohibited from making any such acquisition proceedings in respect of the state, and all those things what has been declared becomes invalid in its nature. So in this way, my friends, we shall see that the acquisition can be made upon with. So this is one area we can go down in understanding with the acquisition. And of course, even after the award is being made under section 33, we can even go for correction of the award. It is not later than 6 months of time, or before making a reference, you can have a correction of those award, something like making reference to that of the order to correct the award of clerical mistake or arithmetical mistake which has been there found in the award, or either on its own motion sometimes, or even on the application made by the parties, they can go for the correction. But no correction is to be made which would likely affect or prejudice to the persons of whom in favor of which the award is being made. If it is going to affect or prejudice the interest of any such person, then again a hearing has to be given in that regard, and only after hearing the person raising the objections, hearing of the person, the collector can pass an award. So collector immediately, once when such is being brought to note, he shall make a notice to the opposite party and hear upon the opposite party, and thereafter proceed for having the award. Or any excess amount that is being said to have been proved to be paid as a result of correction, the same can be also has to refund back by the person who has claimed this compensation, or it would be, if it is not being paid, then it could be claimed as arrears of land revenue from that of the